Go ahead and call to order Woodstock's Planning and Zoning Commission special meeting for March 4th, 2021. This is our annual legal training session, so that is really our number one agenda item tonight. I will note that we have a quorum, but I'll go through the roll call officially. Just say aye that you're here, so that way we note it for the record. Joe Adaletta?
Aye.
Mark Blackmer?
Aye. And Tim Young is trying to sign on right now.
Oh, good. Sid Blodgett?
Aye.
Gail Dickinson?
Aye.
Nancy Frazier, I don't think.
Aye.
There she is. Nancy's here. Jeff Gordon, aye. Jeff Marcotte?
Aye.
David Morris is not able to be on tonight. Doug Porter?
Aye.
Fred Rich, we're told, is not able to join tonight. Dwight Reinowitz.
Aye.
And I guess Tim Young is in process of trying to join. So I'll note that we have the roll. This time, Jeff, I'm going to remember and that we have the Pledge of Allegiance. So are you still on? There you are. I'll have you go ahead and lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Jeff. Our meeting.
My pleasure.
I know commissioners know this. It looks like we have one, maybe two members of the public who are on tonight. So I'll just note that we are meeting virtual via Zoom following the governor's executive orders. Otherwise, our meeting rules are in effect that we normally follow. Since this is really just one agenda item, it will be a simple meeting as far as to keep track of on our meeting agenda. I do ask that people keep their self on mute so we don't pick up any background noise. If someone wishes to ask a question, certainly we can entertain that and we'll go accordingly. Just let us know by raising your hand, or if I don't think anyone's on the phone, but if anybody is, there's I think it's star, I have it here, I think it's *9, if I'm remembering correctly, to raise your hand that way. I will note that even though the chat function of this Zoom meeting is operational, we are not using the chat function. That will be considered a sidebar discussion, which we don't have at Planning and Zoning. So I do ask any members of the public do not be using the chat function at all during tonight's meeting. Otherwise, we do have at the top left the red button that says live, which is the live transcript if you would like to use it. It is available there, and this meeting, as we normally do, is recorded and will be noted to be accessible via the town's website. When you go in to look for meeting agenda, meeting minutes, you can pull it up and see it and click on it once it gets all posted. Does anyone have any questions about our meeting rules and guidelines? Okay. Designation of alternates, we need, I don't know if Tim is on yet, so the only reason we're really going to need a vote, barring something else we want to do, but otherwise would be for adjournment. So I'm still going in alphabetical order. So at this point, it would be to seat Doug Porter and Dwight Reinowitz. I'll note that if Tim Young is not able to join us, then Nancy Frazier, you'll be seated as well. So, but we'll note for right now that I'm going to seat Doug Porter and Dwight Reinowitz, and we'll see what happens later in the meeting about seating you, Nancy, as far as Tim is able to get on. That's all I have for that, other than my chair's report is going to be real quick. If anyone is not able to attend our regular monthly business meeting in 2 weeks, let us know. We are picking back up a public hearing that we had at the applicant's request, reschedule the start of opening. So we just want to make certain we do have a quorum for that. Otherwise, we're working on the agenda for that in the documents, and that will come out at the appropriate time. And my usual thank yous to all the commissioners and to the staff for all the work that gets done at our meetings and in between. Thank you. It is continues to be appreciated. So thank you for all of that. And other than that, that takes us to the star of our show, which is Attorney Rich Roberts for our annual legal training session. First of all, Rich, thank you very much for doing this for us again. And I'll also note that anybody who's going to be attending this Saturday's Connecticut Land Use Legal Training Seminar, I'm actually signed up to attend. Rich, you actually are speaking, I think, on your topic is what, ex parte discussion?
Yeah, conflict of interest and things of that nature.
So we look forward to that presentation tomorrow. Any of us who are attending, we just need to make certain we do a big round of applause and standing ovation when Rich is done with his presentation. So
Grow virtual fruit.
that's right. That's right. So what I'll do is, what we normally do with this is we open it up for Rich to go through where he gives us a review of planning and zoning and that type of stuff and some of those topics. Certainly, if there's anything, Rich, then that you feel from a statutory point of view or a court opinion point of view that we really need to know about. And then I know I'd sent you a few questions based upon some things from my notes that had come up during the past year. And then certainly we can open up for questions from commissioners, if any commissioners have any. But go ahead, Rich.
All right, thanks. Yeah, actually, there haven't been a huge number of significant court cases. The one of them that's probably most relevant to you is actually in response to one of the questions that Jeff sent me to discuss. So I'll cover it when we get to that. So what I thought I'd do is, address the things that, Jeff forwarded on to me in terms of questions. At that point, I thought I might talk about some of the pending legislation. Not too much at all was passed last year, which, was sort of understandable given that they pulled the plug on the legislative session. But right now they're making up for lost time, at least in terms of generating ideas. That can't really predict what's going to come out at the other end. The other thing that I thought, given, assuming we don't run real long, that I wanted to try to talk about a little bit was where things might be going in terms of virtual meetings after the executive orders expire, and how public agencies are going to be conducting their business, in the post-COVID era, because, frankly, we were talking about all kinds of things a year ago, and I don't think anybody predicted any of what it was that has happened since then in terms of how we operate and how business is done and how society might have reacted to things. And at this point, I think it's pretty clear that we've had a shakeout of, at least on the basic level, what works, what doesn't work, and that there seems to be an appetite for sitting at home on a couch rather than driving to town hall, at least among some segments of the population and a lot of people on commissions. So it may be a more permanent structural change. On the substantive things that Jeff forwarded to me in no particular order other than the order that he sent them to me. The first one is question: does the town have to use an ordinance to regulate the land use fees And I guess I want to say that at any point, if anybody has a question, please feel free to speak up. If I'm looking at the document that I'm trying to follow along here, I might not see you raise your hand. So if you have a question, please feel free to interrupt. Does the town have to use an ordinance to regulate the land use fees and the fee process for land use permits? Or can the PZC use the zoning regulations to incorporate and change such? The short answer on that is that, as a general rule, the statute section 8-1C provides that municipality may, by ordinance, establish a schedule of reasonable fees for the processing of applications by municipal zoning commissions, planning and zoning, ZBAs and wetlands, and that schedule, has to set forth all of the different fees. I know that in some instances, towns have tried to sort of by ordinance delegate the adoption and the setting of fees to the to the various land use commissions. Frankly, I don't know, whether that's appropriate or not, and I don't think it's been challenged. The only time it really gets to be an issue is that if for whatever reason there's a difference of opinion between the land use commissions and the legislative body of the town as to what a reasonable land use fee is. And it may take a little effort to get the ordinance updated, but as a general rule, the ordinance is supposed to charge land use fees that are designed to be reasonable in terms of covering the actual cost of the town processing the application. It's not intended to necessarily be a profit center or anything like that. So as long as whatever fees are set forth in the ordinance are reasonable, you should be in pretty good shape. But I would recommend still going with an ordinance rather than trying to, adopt it, kind of bootstrap yourself in through the regulations. The second item, previously there was a discussion about if the planning and zoning could limit or how long a special permit lasts, or put provisions into a special permit approval for a review of compliance at a certain point of time. Can the Planning and Zoning Commission do these things? Actually, that was one of the recent cases that, that came out that is of interest here. The general consensus was that it wasn't specifically authorized by the statute to have a time limit on a special permit, and that the fact that site plans do have time limits on them and special permits don't in the statutes, that you would not necessarily be able to put a time limit on the special permits. And there was a Superior Court decision back in 2019 that sort of got people a little agitated because it was essentially the first time that a court had clearly held that time limits on special permits, were unenforceable and illegal. A lot of places had been doing it as a matter of course, giving you a special permit for a period of X time. We're giving you a special permit, that expires in 2 years if you don't start the work, that sort of thing. And the Superior Court decision was basically that since it wasn't specifically authorized by the statute, it was illegal. Last month, the appellate court here in Connecticut overruled that decision and basically said that time limits on special permits were valid as an extension of the town's ability to you know, to regulate the land uses and set whatever terms and conditions they think are appropriate. And the specific time limit that was questioned in that case was one that had the special permit expire if the work hadn't been done within a certain period of time. It wasn't a case where, you know, the special permit was granted for a 5-year period, at which time it, you know, it expired or required the applicant to come back to the commission and, you know, essentially either reapply or, you know, confirm that it's still an appropriate use. So that type of permit expiration date where it's tied to the commencement or the establishment of the use was specifically found to be valid. I think a lot of people are reading the case broadly to say that any kind of time limit on a special permit is permissible. I'd be wary of that for two reasons. One, the situation here was one where it was, you know, you get the special permit and you sit on it for 15 years before you build your project. The analogy that they used was that if, you know, someone had gotten a special permit to build a crematorium in a particular location, and then they just sat on it for 30 years and didn't build it. And in the meantime, the whole neighborhood in which it was to be located had been developed for single-family residential homes, or in a way where it was no longer, you know, compatible with the neighborhood, consistent with the plan of conservation and development and so forth. All the, you know, all the sort of general criteria that you use to evaluate a special permit application. You know, the court basically said that you can't count on it being consistent and compliant with those regulations forever if you don't actually do the work, and that it was reasonable for the town to have imposed that time limit in that situation. The first reason that I'm kind of wary about how broadly that case is going to be interpreted is that, you know, it was the appellate court, which in Connecticut is one step below the Supreme Court. And there have been a number of instances recently where the Supreme Court has taken kind of bizarre positions on land use and zoning matters. You know, the superior courts and the appellate court come up with something that kind of makes sense in a real world context, and then the Supreme Court sort of on, you know, either hyper technical grounds or some other basis overrules them, and then we go back to kind of an unworkable situation. So I'm wary about how reliable the appellate court decision is for that reason. The second reason is, you know, as a matter of equity, I can understand why, you know, someone would come in and get a special permit to put in a Dunkin' Donuts drive-through and or a crematorium or something, you know, and the commission evaluates the circumstances at the time the application is filed. And, you know, 22 years later, they get around to building it, and, you know, the town's vision has changed, the plan of conservation of development has changed, the character of the neighborhood has changed. There's 7 other Dunkin' Donuts already. So, you know, there may be legitimate reasons why you don't want to start a new use, you know, decades after it was approved. But I don't really know whether the same arguments apply if someone actually goes out, you know, promptly builds the facility, puts it into use, and, you know, it functions as intended. And then 5 years later, the town, you know, decides, never mind, we didn't think this was such a good idea after all. it kind of undermines the whole concept of a non-conforming use, but it also strikes me as, being relatively arbitrary, or at least susceptible to being arbitrary and unreasonable in terms of taking away, a property right that you've granted to someone because you've made the determination that it's an appropriate use. You put some conditions on it and they go off and running. I guess the kind of the further caveat on that is that, you give someone a permit with a term of years to do something, at which point, they're directed to come back to the commission. If the use and the activity turns out to be problematic for one reason or another, but the problems are ones that can be fixed either operationally or physically or somehow, then I think there's probably a good argument that, after 5 years, the commission can modify the special permit to say, we're changing your hours of operation. We're going to require you to do some improvements to the site just to, to ameliorate consequences of what you're doing. But I think you'd be hard pressed basically after someone, spent the $1 million to put in, the Dunkin' Donuts drive-through and the Verizon store, if you gave them a 5-year permit to say, yeah, this wasn't such a good idea. You don't fit our vision. Please stop using your property. And I can envision that type of argument being the one that sort of narrows the scope of the recent appellate court decision that validates time limits on special permits.
And I'm just going to quickly just note for the record that Tim Young has joined us. So welcome, Tim.
Good evening. Yes, I'm finally here.
Actually, if anybody would like to read the court case, which is, I think that's that international investors case.
Correct.
I read it through. It's actually interesting. Some of the comments in the opinion, we can get you a copy of it if anybody is interested in reading through it, as far as how the appellate court came up with its reasoning. But it sounds like, if I'm correct, Rich, as far as what this opinion kind of is saying is that separate from a special permit running with the land, that the court in this case said, but you could put a time limit on when someone could start. So if in this case, one would say, well, yes, you can get your Dunkin' Donuts, for example, but you have to start building within 5 years. Otherwise, too bad. Yeah. Versus you build it in 2 years, you can't then come back and say, nah, we don't like it, abandon it type of thing. It's more how long it would take to actually start construction or something like that. Seemed to be where the court was coming from, not opposed to once it's already built, retroactively negating it.
Yeah, I mean, that's exactly it. And your comment about, running with the land is, one thing that I didn't mention, that, the sort of land use phrases that roll off everyone's tongue is, the permit runs with the land, the variance runs with the land. The whole concept of the land use permit running with the land is designed to sort of distinguish it from being limited to a particular person. So, you give a special permit to build a Dunkin' Donuts to Tim Young because Tim's a good guy and everybody knows he'll do a good job building it, but you can't limit it just to him. He could sell it to the worst person in the world the next day, and the permit would still, follow the property. So the kind of the repeated mantra of, it runs with the land, was being, held up as, the counter argument to the ability to put some kind of time limits on it. And I think the court actually did a pretty good job of sort of parsing those words and saying, yeah, I mean, it clearly runs with the land, but the intention of that phrase, is that it's personal, not that it's necessarily permanent.
Can you keep commenting on that? What do you mean? For the land and not the person, or for the person, not the land?
You, when you give a variance, when you give a special permit,
Right.
you can't say that this special permit is valid for as long as Dwight owns the property.
Right.
Quite often people use a term of years as a proxy for that, and to date that hasn't been overruled, but there actually were cases, where someone was allowed to, they got a variance to use a seasonal cottage year round for so long as Mrs. Lord is alive, and that was sort of the first case where they said, no, that's not how land use works. It's the activity and it's the property. It's not necessarily the person who owns it. But, as with everything else, I think people have kind of figured end runs around that sort of thing, and actually, putting a term limit on certain land use approvals, or requiring them to be renewed with some regularity. Tends to achieve the same purpose, to some extent, which may be again why that sort of thing where your time limit is on the terminal end of the permit rather than at the beginning, maybe maybe challenged more successfully.
So it becomes important to really describe what the use is for that special permit for the land. For example, a car dealership versus a car repair garage, or a retail operation that has a special permit to sell clothing, and then that goes out of business, and a retail operation to sell automobile parts. Just because it's retail, is that the category that carries the day? Or is it important when we look at a special permit to clearly identify what the special permit use is for the land, and not just rely on retail or wholesale or manufacturing or broad categories like that?
I think if it's something that you are truly concerned about getting away from you, finding objective criteria to tie the special permit to, in terms of, square footage, hours of operation, parking spaces. If you differentiate among, different types of wholesale, retail, that kind of thing, as long as there's some rational basis to limit, the special permit to one particular use, that the impacts are no different from one kind of retail to another, within certain ranges, you're probably, okay. But I mean, if it's retail of, domestic goods or something like that, as opposed to, retail of industrial goods or something like that, as long as there's some legitimate differentiation among the different types of use, you're probably okay kind of narrowly confining it. I mean, a lot of times, I think commissions tend to approve the special permit as submitted, including, the hours of operation, the number of employees, those kinds of things, which may, in some cases unnecessarily restrict the use, but at least you know what it is that you're going to be getting. You don't approve, a yarn store and end up with Dollar General. So it's kind of a fine line. I mean, you don't want to, make the the criteria so narrow that you inhibit the ability of the, you know, the permittee to move within certain narrow bands, you know, of legitimate uses while still not getting to the point where you're, you know, you've completely lost control of what's going on.
Thank you.
In terms of time limit, if, for instance, someone, this is just an example, it has nothing to do with anything that's ever been applied for, wanted to have a Saturday flea market on a big piece of land, someplace in Woodstock, and came in for a special permit for that. And we have some reservations about how it's going to work in terms of traffic and crowds and noise. Could we give a special permit for 2 years and say they have to come back and be reevaluated at the end of the 2 years and apply for another special permit?
Personally, I think that's reasonable. I mean, if it's something that, you know, that is new, that hasn't been tested, you know, and you find out that it works fine, then, you know, go ahead and it's great. But if you find out that, you know, traffic is backing up and that you need to, you know, either limit the hours or require that it move to a different part of the property or require that they provide, you know, traffic detail or something like that based on your experience, I think that's reasonable too. I guess the, you know, the hypothetical that I threw out of somebody spending $1 million to build a building and then, you know, 2 years later you go, nah, that that isn't what we had in mind. You know, I think you'd have a much more difficult argument than if somebody was basically using a vacant piece of property and then you found out that there were, you know, legitimate health, safety, or property value concerns that were associated with it that could be fixed in some way. You know, I think that type of we'll revisit it is legitimate. All right, next subject, which Chairman Gordon is trying to be sly about and make everyone wonder what he's talking about. If the state were to legalize something that in federal law is illegal, then how might the Planning and Zoning Commission handle the discrepancy from a regulatory point of view?
Just to preface, the reason I ask this is not so much that we've been asking this a lot. It actually is seeing what others who I know are on planning and zoning commissions or other chairs in other towns, kind of some of the issues they're wrestling with in the real world. And so I figured I would ask it because I know it is a hot topic, so to speak. And some other towns are actively in the midst of trying to sort it out.
Yeah.
Let alone the courts.
I know. Well, I don't honestly know that it's come up in Connecticut in terms of land use, just because the, you know, other than the medical marijuana, there hasn't been a, you know, a legalization or decriminalization or you know, cash cow scheme set up yet that has triggered that question. You know, I'm on the commission in the town that I live in now, and when we were talking about revising the regulations to allow medical marijuana dispensaries, you know, a couple of people on the commission were basically said, no, I'm going to vote no because it's against federal law and I don't want to violate federal law regardless of what, you know, the state of Connecticut says. And, you know, frankly, I don't know how a court would treat that kind of reason for a denial. The difficult thing for you as a, you know, planning and zoning commission in Connecticut is that you only have what powers have been delegated to you by the state of Connecticut under, you know, Title 8 of the statutes. And if they, you know, tell you that you can do these things and that your powers flow from the state, and the state has also set up kind of a parallel system where it tells you that certain uses have to be allowed in town. I think it's difficult to know whether, you know, you can raise the you know, it's illegal under federal law argument as a defense to not wanting to do what the, you know, the sovereign entity that created you is telling you to do. I mean, it's a fascinating question. I guess one small comfort is that in the governor's proposed adult use cannabis bill, it does provide municipalities with the opportunity to basically prohibit, you know, the establishments that are going to be selling marijuana in town. There's still the carve out for the medical program, but you know, local option prohibition is something that is in the current legislation. One thing that's interesting about that is that you can have it in your zoning regulations, but the zoning regulations prohibiting it can't take effect until they've been approved by the legislative body of the town, which is the town meeting here. So, you know, you can pass zoning regulations saying, you know, we prohibit, you know, recreational marijuana sales, and that can't go into effect unless the town meeting agrees. And if the town does not either impose restrictions or an outright prohibition in the zoning regulations, the default provision of the bill is that you have to treat the excuse me, the, you know, the marijuana establishments like you would any similar establishment. And I don't know whether, you know, here in that case, whether we're just going back to retail, you know, of you know, herbal supplements or what, you know, as far as they consider to be a like use. But you know, the short answer is if the bill passes as drafted, you know, the town would have the opportunity to establish basically a local prohibition, or you can impose restrictions. And if you do neither of those things, it would basically be treated as an as of right use that could be only be regulated in the same manner as other retail sales of similar products.
Well, it's an interesting topic because there's a number of towns that have created or looking to create some task force to look into it, including zoning. So it's a rapidly moving target because of the bill that's in the legislature. So it's going to be very interesting to see what a lot of other towns do as they're that have some dispensaries already and what they're might draft up for their zoning or not, and who challenges what. So it's a very interesting open subject.
Yeah, it really is. I mean, and the way it's been teed up by, you know, in the legislature, it's got so many different aspects to it that, you know, never mind just the, you know, are we going to sell it or not, you know, but the, you know, the criminal justice aspects, the social equity aspects, it's and the money. You know, it's an extremely complicated subject that probably will, you know, be the source of a lot of discussion and controversy going forward. Next was previously the Planning and Zoning Commission was informed that it could put into the zoning regulations about the ZBA not granting use variances separate from the hardship variance. Please update the Planning and Zoning Commission as to what can and cannot be in the zoning regulations regarding limiting anything the ZBA does. Basically, there are two types of variances, you probably know. You know, for lack of a better description, you have dimensional variances, which are things like, you know, setback, lot coverage, height of buildings, you know, how many car garage you can have in the side yard and that sort of thing. And use variances, which is where the use that someone proposes to have going on their property doesn't necessarily comply with the zoning regulations. So they go to the ZBA and get a use variance. And the long and short of it is that even if you're going in for a use variance, you still need to have some kind of hardship. You can't go in and ask for a use variance just because you want to do something that isn't permitted by the regulations. You have to show that prohibiting you from doing what you want to do is unfair because of how the zoning regulations are written, or because of the type of property that you have, or some other feature of the zoning regulations or the property itself, rather than just, kind of a personal desire. And hardships have been very narrowly construed by the courts recently. And in some cases, it's essentially that, the outcome is that if you don't get the variance, you basically have been denied any reasonable use of your property. One kind of exception to that, now that the courts have been much stricter about hardship, one of the exceptions that a lot of people have been kind of piling onto is it's called Adolphson, just because that was the name of the case. It doesn't require that you show a hardship in situations where what you're doing is reducing the nonconformity. The original case, I think, was for example, I think it was like a scrap metal recycling facility that wanted to turn into something, equally industrial but less noxious. And the court found that, that variance was supportable even without a hardship, because it was, reducing the nonconformity. So now that, the court has been a lot harder about finding a hardship, more people are, running down the avenue of saying, well, I don't have a hardship, but I'm reducing the nonconformity. And a lot of them have been, for example, rebuilding properties down along the shoreline where they want to knock down and rebuild. And, reducing the nonconformity means they're taking the shed out of the setback, but they're keeping the rest of the house where it is and making it 10 feet higher. So it's kind of an end run, but under that specific line of case law, they haven't had to prove the hardship. I think the starting point for what you can and can't put in the regulations is basically you can't prohibit use variances entirely. You can restrict them, but you can't prohibit the Zoning Board of Appeals from giving use variances. And I don't honestly know that this comes up too often in Woodstock. It doesn't sound like the ZBA meets all that often to begin with, but use variances are relatively uncommon. But what it would allow you to do is to do something in the zone that would otherwise be prohibited by the zoning regulations. And so the kinds of things that you might want to consider, including in your regulations as, restrictions or requirements on use variances would be, for example, not permitting a use that would not otherwise be allowed anywhere in the town. That the applicant would have to show that they can't make any other reasonable use of the property. That the use variance can't create the expansion of a non-conforming use, that the use variance doesn't result in a multifamily use or development that would otherwise have been prohibited in that district. You can't, or you could include in your regulations that you can't get a use variance to do something that would have been allowed by special permit if you had applied for that. So you can't, you can't allow people to go basically forum shopping and say, planning and zoning has been really tough on special permits. I think I'll just go get a use variance instead. And one of the other things that I think, might be good if it isn't in there already is that you require any application for a use variance to be referred to planning and zoning for review and comment before the zoning board of appeals can act on it, essentially so that you get an opportunity to know what's going on and to weigh in on it and say, we don't think this use variance is appropriate because it's a use that's otherwise prohibited in town, or in your perspective, it's inconsistent with the plan of conservation and development, or for whatever reason, you don't think it would be appropriate. The last specific item in Jeff's list was ex parte discussion. And that's something that comes up fairly regularly. It's kind of a common subject. And, unfortunately, it's also very complicated. The basic premise of ex parte communication is that you want to have all of the discussion relating to an application be done within the confines of the public hearing, where all of the members of the commission, all of the members of the public, and the applicant can be involved in the discussion, can hear the information, can evaluate it, and so forth. And it under the heading of fundamental fairness, that's certainly a laudable goal, and definitely something that that should be aspired to. The practical difficulty is that you have meetings once or twice a month. There may be a very controversial thing that's pending before the commission, and you don't live in, well, at least before COVID, you didn't live in bubbles where you never exposed yourself to neighbors or people in the outside world. So you'd be standing there pumping gas as a kind of a captive audience while people were telling you what they thought of the application, and you just can't really get away from it. The ideal response in that kind of situation is to let the person know that's great, the hearing's open, please come and talk to the commission about it. But that's sort of an unreasonable expectation for commission members in how they interact with the general public, particularly family and friends who know you're on the commission and bend your ear about things. Where I think you really need to be careful, and these are the ones that that are the ones that give a legitimate basis for someone to complain, is where the information that you are hearing is both evidentiary and prejudicial. And those are great legal terms, and what do they mean? It essentially, I think, means that you're getting information that is relevant to the application, and that is something that kind of in the objectively viewed world is something that the commission as a whole would want to know and consider in the course of deliberating and voting on the application. So, if the person talking to you is the 57th person to tell you, Jesus, this is the stupidest idea I've ever seen, I hope you never approve it, that's not evidentiary. That's just kind of piling on. And frankly, it's probably not prejudicial either, because it's just, kind of opinion. But if what you're getting is, technical or engineering or, factual data that is relevant to the application, either pro or con, that would tip the scales in one way or another, in your mind and in the mind of the average commissioner, then it's probably, evidentiary, and there should be some way either to get it into the record for the public hearing or make sure that it does not factor into your decision making. The second category is prejudicial, meaning, if this information is provided, or if it's something that and you spring it out after the hearing has closed, and the applicant or the opponents or members of the public don't have an opportunity to respond to it, to kind of, either explain it away or to, otherwise address the substance of it, then in that context, it could be a problematic ex parte communication. And, in the grand scheme of things, most often, the 57th person telling you this is a dumb idea, or somebody telling you a variation on the theme of what, had already been provided as testimony at the hearing and so forth, those aren't the kinds of things that a court is going to use as the basis to overturn, the commission's decision if there is otherwise substantial evidence in the record to support your decision. I think the important thing, though, is, to be sensitive to making sure that any and all information that you think is relevant to the application gets put into the record during the public hearing, so that members of the public, the applicant, the opponents, town staff, other commissioners have an opportunity to ruminate about it and to, either challenge it or pick it apart, or to, to supplement it, just so that there's, a fair and complete discussion, before the hearing closes. So that, that's probably the long and short on ex parte communications. The cases that have overturned commission's decisions, on the basis of ex parte communications have by and large been, really egregious situations. There was one, where it was a subdivision application, and they talked about the open space and all that kind of stuff. And then they, closed the public hearing, and at the next meeting a month later, the town planner presented a lengthy memo explaining why the open space was all wrong, that they hadn't complied with the regulations, and it was, it was something that was debatable. I mean, it wasn't black and white. And, the applicant basically said, the commission made their decision to reject the application based on, this information that the town planner had provided, that they would have had good explanations for, that might have resulted in different outcomes. So, at the end of the day, that's the kind of thing that you need to worry about, is whether, what information you're receiving or sharing is anything that, the applicant should have had an opportunity to respond to.
And Rich, that's different from a process communication, such as sometimes a chair through the staff or with the staff has to say, well, for some reason, we can't have a meeting, we're in the midst of a public hearing, but town hall's lost power. After a storm, there's no way we're going to be able to have a meeting. So communication goes out to all commissioners saying, no meeting, we're working on rescheduling, even though it's pertaining to the public hearing. That's more of a administrative type communication, not anything that's to the merits that anyone would use to make a decision on the application.
Yeah, I mean, and I think I might have talked about this last year too, is that, particularly now in the world of, everything being virtual and electronic, reply to all communications about scheduling and so forth is, it's almost universal in terms of, we can't have the hearing because the power went out. Is anybody available, on March 16th for a special meeting? That kind of thing. Just kind of run-of-the-mill ministerial, you know, administrative matters. Those are basically all fine. It's, once you start straying into the merits of something, it's like, no, I'm not coming on March 16th because that applicant is a jackass, and I'm not gonna, get out of my house to go to that application. Um, those kinds of things. That's when the world goes sideways pretty quickly. And unfortunately, I think in the real world, reply to all is a wonderful way to communicate, but not when you're a public agency that's supposed to be doing your business in public rather than, from the comfort of your own home, conspiring to undermine people's property rights. So.
So I was interested in the example you gave, the town planner who gave an opinion, because we can get information, I thought, from staff after the public hearing closed.
Yeah, you can get information. That I think what was interesting about that situation was it was information that was more in the nature of an opinion than it was of fact. If you get a memo from the planner that says, yes, I've reviewed the plans, they comply with the requirements of the zoning regulations, or we confirmed with the fire marshal that he had no issue with something, those kinds of communications are better than, in my opinion, the open space should have been provided in a different area of the property, and what they've proposed to do is inconsistent with the plan of conservation and development, rather than just kind of straightforward, definitive information that kind of puts a bow on, the discussions or the deliberations or the open issues that might have existed during your hearing. I mean, a lot of times it's, confirm with the town engineer that the flood storage capacity is adequate. Those kinds of things that are, that are more objective and, technical. That particularly if it's nothing that, that's prejudicial to the applicant. If afterward you ask the town engineer to review the plans and they come back and, essentially tell you that they should be completely redrawn, then I guess you have a different question, such as, why didn't you tell us this before we closed the public hearing? But
So for example, if we were to bring up during a public hearing, reviewing through Design Professionals is the firm we use for engineering, and they issue us this 10-page report, and in one item, they make it's a little confusing if they were saying, I want a 2-inch pipe, or if the 2.5-inch pipe as proposed is fine, for example, something like that. And we had a technical question raised during the public hearing to say, let's just clarify with the engineer that the engineer is indeed fine and there wasn't some problem, raised. That type of stuff we have to keep the public hearing open for, or is it that stuff we can get back after? Because one of the questions is, if we're trying to clarify something, what happens if the applicant didn't agree with the engineer or
Yeah, I mean,
something?
I think that is kind of a tricky area where you're trying to clarify something where there are multiple possible outcomes. It might be different from, confirming something with the engineer, where the applicant's engineer says, no, I talked to design professionals. They said the 2-inch pipe going into the riprap would be fine here. You can close the hearing and then have that discussion. And, if you want to make one of the conditions of your approval that, the pipe into the riprap be designed in accordance with, or subject to the approval of, our engineer or something like that. Just where there's not a possibility of completely having to redesign, the whole project on the basis of, uh, things that need to be either clarified or decided as opposed to just confirmed.
And actually, when you were talking about the ex parte discussion and you mentioned about wanting to be prejudicial towards applicants, and I know as a commission, we do, I think, a very good job being as fair and objective as we can in giving applicants opportunities to present their information and to be heard. I don't know if you want to touch upon in general about the whole concept, and I know you've talked with us prior years about this, about bias and that type of thing, separate from ex parte discussions, but that whole concept of bias, because I know, like the example you said where, a commissioner may say, well, I don't want to show up for this meeting because I think the applicant is a jackass or their idea is, is the worst thing I've ever seen, type of thing. That, especially if you state it publicly or on the record or something, I know there's been some issues where people have challenged that type of stuff.
Yeah.
As far as how objective a commission really is. I'm not saying that's affected us, but there's been some court cases that are interesting to read that you kind of read through and you're like, did someone really state that on the record or, otherwise write that type of thing?
Yeah, I know. I mean, and frankly, that would be a spoiler for what I have to talk about on Saturday. So I'm not going to give it all away. But yeah, I mean, if you look at, if you look at some of the cases that have come down over the years, I mean, reasonable people just kind of shake their head and say, I can't believe anybody would actually have done that. The important thing with respect to, to bias and predisposition is that you have to show up with an open mind. You may have an inclination, you may have opinions, but at least when you walk into the room or when you log into Zoom, and the hearing begins, you haven't made your mind up already, either because you don't like the applicant or you really like the applicant, or you just in your heart of hearts can say, there's no way on God's green earth I'm ever going to vote in favor of this before, regardless of what anyone says, before the hearing opens, that's when you run into trouble because, basically there is no fairness in a process where regardless of what anyone says, you've already made your mind up either yes or no. And where you get into trouble is when you tell the person during the public hearing that I don't really care what you tell me, I'm never going to support this application. And it's happened, and it probably happens fairly often. I guess my advice as your attorney is, if that's the situation you find yourself in, just don't say it. And certainly don't telegraph it with, hand gestures and sighing and eye rolling and things like that, and, so forth. Um, the whole premise of land use hearings is that, you're coming in not necessarily with, a completely blank mind with no opinions, but that you're seeing your job as, enforcing the regulations, hearing the application, applying the regulations to it, and that you evaluate fairly the information that's provided to you. I think it's not uncommon and it's not irrational to have opinions about land use development in the town you live in on a commission that you've served on for a long time. But I think the difficulty is, if you come in, with the perspective, particularly if it's because of, who the applicant is or who the opponent is, or, what group they might be affiliated with, that there's, no way you're either going to approve or deny the application, that you're basically doing a disservice to yourself and to the community. And that you should approach things with at least the mindset that, all right, we've got the regulations, we've got the application, I'm going to hear the testimony, apply the testimony and the application to the regulations, have a conversation with my fellow commissioners and then vote. So, as long as you come in with that perspective, I think you're fine. But if you wake up in the morning and see what's on the agenda and go, nope, then I think there's a legitimate basis for someone, claiming that they didn't have the opportunity for a fair hearing because you were, predisposed either for or against them.
And one question for that I have is, and this came up some years ago, where an applicant actually ended up getting something approved with some conditions of approval, but had raised a question after the whole thing was done, not to the commission. I heard about it as chair that, why was it that some commissioners who are duly seated at a meeting may not have said anything at all while the application was being presented and discussed, but yet took a vote. My answer was, you're not obligated to have to ask questions or say anything. We spend a lot of time on the commission listening to what's presented and hearing what people have to say, but that doesn't preclude any commissioner from voting at all, because a commissioner can just sit there and listen and absorb it all in, and maybe questions that he or she had were already answered and thus didn't feel the need to have to ask them again. So there's correct me if I'm wrong, Rich, but you have no obligation as a commissioner to even speak while technically while the application is, before you. You can certainly vote upon it, but you have that opportunity, but you can't be compelled to do it.
No, I think that's exactly right. I mean, if you're sitting there and listening to the testimony and thinking about it and evaluating it and, processing everything fairly, you don't need to, ask questions if other people have asked them, or if the applicant or members of the public have already, produced the information that you would have been asking for. Ironically, some of the cases where people who have been disappointed at the outcome raise the claim of predisposition is that, you have 3 nights of testimony and 25 public speakers and experts, and then you get to your meeting where you're making the decision, and the deliberations take 2 minutes. Their argument is, oh, come on, they must have already made their mind up. And, courts have basically said, without some kind of, actual evidence that people had, in fact, made their minds up before the hearing started, the fact that they made their minds up during the course of the hearing and voted quickly, isn't enough to show that there was predisposition or any kind of unfairness in the process. Again, and I think that's worth noting is that, if you make your mind up during the hearing, that's fine. What's problematic is that, if you've irretrievably made your decision before you hear any of the evidence and, come in saying, I don't care what anybody says, I'm never going to vote for this. That's the kind of thing that will be problematic.
Was there something you had a question, Joe?
Yeah, just two quick questions, if I might. And one of them just goes back to the first question, Rich, about whether the zoning commission or the selectman's office or by ordinance or regulation should implement fees. What about fines? Is that something that should go through an ordinance versus a P&Z regulation?
The whole concept of enforcement, I guess, that's a bigger subject than
Okay.
we want to tackle now. I mean, they're basically two tracks of enforcement. One is under, I think it's 812A. It's essentially you have a zoning enforcement officer. You tell them what to do, they go out and enforce. They can levy fines of up to X dollars, and you can go to court to collect them, and you can get injunctions and those kinds of things. That's entirely within your jurisdiction. And I think the amounts of the fines are set by statute. The other track that a lot of towns have gone down is essentially a citation ordinance, where the town sets up a process by which violations of snow removal ordinances, dog waste ordinances, zoning, wetlands, all those kinds of things can be enforced by various town officials, through the issuance of citations. And, they're basically like zoning tickets that you can give out. And it's an absurdly complicated and poorly written statute that sets it up, because they're, not to be unfair, but I mean, the idea was, to create a process that provides a great deal of due process for the people who, are the ones receiving the tickets. So, you can, if you wanted to create this type of enforcement mechanism, you would, set up a citation ordinance, set up a hearing panel ordinance, and then authorize the zoning enforcement officer basically to write zoning tickets. And you give the tickets to the people who are violating, and they have a certain amount of time within which they can either pay the fine or they can challenge it and get a hearing before an officer. If they basically blow you off, you can continue to issue the citations while the violation is going on. And then there's, a 30-day period within which certain things have to happen. And, the long and short of it is that it's kind of a morass of procedure, but at the end of the day, the amount of the fines can accumulate quickly and badly. And then you go through the process of trying to get them reduced to a judgment against the person. I think if you're finding that, zoning enforcement is a problem in terms of getting compliance, it's probably worth looking at the two alternative paths and figuring out which one might work best in town. I would hazard a guess that the ordinary zoning enforcement statute probably would be more efficient. But if there are a lot of different types of town ordinances that, that people want to enforce and start trying to raise revenue from, you might want to look at the other mechanism, but that's one that you really have to tread carefully in terms of following the exact steps and processes set forth in the statutes. Otherwise, you're going to end up with nothing, and you get no money, and you've basically, wasted a year of effort trying to get compliance. But
Well, it's only come up a couple times, I think, when the ZEO has an issue and they issue the NOV and no action is taken, and another NOV, and when the commission hears after a few months that really the complaint hasn't been addressed, didn't seem to be that many tools readily available to help drive compliance, but it's not a frequent issue. So just don't want to belabor it, but just curious.
yeah, I mean,
Yeah, we've looked at this before and actually have drafted up a proposal, which actually is modeled on what inland wetlands, I believe, already has in ordinance, which is very similar to what state statute allows zoning commissions to do. And I think we even have fines for if you violate the fire safety ordinance. And I think there's even a fine if you violate the non-nuclear ordinance the town has, which went into effect many years ago. So the proposal that this commission had looked at before and had reviewed was basically cut and paste, copy and paste from state statute, and exactly what is also allowed for inland wetlands separately.
yeah. Well, the wetlands has kind of an incentive for enforcement because those fines are huge. I mean, it's like $1,000 a day. So, if somebody's really messing up with the wetlands, it can, it can be very costly, and it can support the expense of enforcement, because it's generally, something that may not be fixable if it goes on for an extended period of time. And also, wetlands is essentially enforcing state regulation rather than its own. So, but I think, yeah, I mean, zoning enforcement, particularly if it's something that isn't a constant issue, is one that is probably, best handled using the statutes that are specific to zoning enforcement. And, if you've got people that aren't behaving properly, let us know, and we can, give you some direction on the alternatives. Unfortunately, you have to rely on the courts so things don't move very quickly. But on the citation side, you spend so much time trying to make sure that you've dotted all the I's and crossed all the T's that it's frustrating for the amount of effort that you have to put in.
If I could just touch on another quick question about the governor's executive orders through this pandemic. Do you know if that's also extended the life of certain permits, like 5-year business permits or home occupation permits? I know it's extended a lot of our timelines for things, but has it applied to those already issued permits?
No, actually, that was one of the pieces of legislation that I was going to mention. And I'll do that now because that was where I was going to go next.
Nice segue there, Rach. That's all.
Yeah, I know. It's almost like we choreographed this.
Does that mean you can hire Joe as the town attorney now?
Yeah, sure. Or at least the facilitator of conversations.
That I could do that, yes.
Yeah.
We'll double your pay, Joe.
The executive orders basically extended the expiration of a lot of permits up until the end of the state of emergency. And there actually has been kind of a discussion, in the land use legal community, the governor's office and so forth, whether it just basically extended everything until the end if it was going to expire, or if it extended everything by the amount of time within the executive order. And my sense is that the governor's office believes that, you know, anything that was going to expire during the year of COVID, you know, has been extended by that amount of time. But there's raised bill number 970, which essentially codifies that by adding a year to the expiration date of pretty much anything that hadn't expired on or before March 10th, 2020. So it was designed to, you know, to clear up any ambiguity, because, you know, frankly, the worst case scenario would be that on, you know, April 21st, 2021, you know, 25,000 land use permits all expire by their terms, you know, because they had just kind of been, you know, bumped along during the executive orders. And it's like, okay, you know, flip a switch, now it's over and you're all expired, you know. So that, you know, it was designed to push everything out. And it's, you know, as written, it's for site plan, special permit, wetlands, subdivision. You know, it's basically any kind of land use permit that had a time frame associated with it, you know, gets extended by a year from when it ordinarily would have expired, provided it hadn't expired before March 10th last year.
Thank you.
Yep. One of the other pieces of legislation that people have been interested in, I mean, and there are probably 2,000 proposed bills that have been introduced, and Planning and Development Committee probably has 150 of them in their you know, roster. I wouldn't be surprised if maybe only a dozen come out, and a lot of them are ones that are absurdly specific, like, you know, the taxation of certain property within a certain fire district in the town of Canaan, you know, and things like that. But number 698 is one that's been getting a lot of attention. It's essentially allowing towns to post on their website anything that the law would otherwise have required them to publish in a newspaper. And it's been, I don't know, I think it's been ever since Al Gore invented the internet, people have been trying to get, you know, this bill passed. And every year the lobbyists for the newspapers fight it back and say, you know, we're essential, you know, don't cut out this, you know, tremendous revenue source for us, you know, and it ends up, you know, not passing. And the one thing that's different this year is that, you know, for the most part, maybe not for the most part, but in a lot of instances, towns have been allowed under the executive orders to publish things on the town website rather than in newspapers. And members of the general public have gotten used to the idea of going to the town website rather than, you know, squinting at the tiny print in the Norwich Bulletin or reading the, you know, underneath the obituaries in the Villager to find out what's going on in town. You know, but I frankly would anticipate that the newspaper lobbyists will, you know, push back just as hard on this one as, you know, they have otherwise. But, you know, I think the fact that we've had a year's worth of experience where, you know, legal notices have been published on the town's websites, and, you know, newspapers are still being published and business is still being transacted, might make it slightly more likely that it'll pass this year. One of the things that a lot of people have mentioned is that they would like to see some provision in the legislation that requires that the town post the legal notices in a place where it would be reasonable to be able to find them. Because I don't know if any of you have ever tried looking in various towns to find the legal notices, but some places they're under the commission, sometimes they're under news, sometimes there's a tab called legal notices. So, it's not intuitive necessarily as to where they might be on a town website, and they're all set up differently. But that's one piece of legislation that has been getting some attention. A couple of the ones that I think you guys as planning and zoning commission members and just members of the general public have been made aware of are some of the legislative proposals regarding affordable housing opportunities, fair housing. Last summer, the Desegregate Connecticut organization promulgated a 50 or 60 page draft bill. Senator Anwar from South Windsor presented that. I think it was back in July, and it had a lot in it, and it, for better or for worse, well, I think for better, it's provoked a lot of discussion, and it's provoked a lot of thought in terms of what zoning should be in terms of providing reasonable housing opportunities, versus preserving municipal character. The debate rages, and I don't know where it's going to go this session, but at least as of now, that larger bill with lots of parts hasn't come up in in the form where it's being presented to one of the committees for deliberation. There was some thought that there was a concept bill that Senator Anwar had introduced, that may have been, like, for lack of a better word, the Trojan horse that would turn into the 50-page bill that he had produced last summer. But that has yet to materialize, and as time goes on, it seems less and less likely. There are at least two bills that appear to be getting serious attention, that would propose revisions to the general zoning statutes, zoning enabling statutes. The one of them that is a little more detailed and a little more focused in terms of affordable housing is Bill 6521. And the primary focus, at least as that bill is sitting out there now, is to create or to mandate as of right accessory dwelling units, basically for every single family house where it can be done, consistently with the zoning regulations, and to encourage accessory dwelling units, where appropriate and where possible, and to give credit in terms of affordable housing counts and criteria, for the accessory dwelling units. So, it's not necessarily a second house on the property, but it might be, an in-law apartment or, that sort of thing. I mean, just basically another opportunity for, residents within, the property containing a single family residential dwelling. It has, a couple other provisions that are interesting. One is that it shortens the restricted period for affordable housing developments. Right now, if you want to go under what's referred to as 830G, the Affordable Housing Appeals Statute, you have to have restricted the property for a period of 40 years. It proposes to shorten that to 30. One of the other things that it does is, and I don't know whether, I can't remember you guys ever having confronted it before, where you're having a map change on the zoning map, and people who surround the property where the zone change is proposed for can circulate what's called a protest petition, where basically if 20% of the people within 500 feet of the area that's proposed to be rezoned sign a petition saying we oppose it, it raises the requirement, the voting requirement for the commission from a simple majority to 2/3 to approve the map amendment. And what this bill proposes to do is to put that back down to a majority of the full members of the commission, which kind of doesn't really accomplish anything because, it takes a majority vote. I guess the only difference is that, you have to have a majority of the full membership of the commission, just not necessarily a majority of those who might be present at a meeting. But, it seriously undermines the significance of a protest petition. And the only reason I think that, that's noteworthy is that it's in the affordable housing bill, but it has nothing to do, or it's not limited to affordable housing. So if you're in a neighborhood and, somebody wants to rezone a piece of property, for multifamily, that could be objected to by the neighbors who sign a protest petition, and that would be a legitimate subject for the affordable housing bill. But, going back to the parade of horribles earlier, I mean, if you want to rezone, 10 acres of currently residentially zoned property to industrial so that you can put in a crematorium, it likewise reduces the significance of the protest petition in that situation, so that, the rights of the property owners around it are reduced from what they are currently. And that bill also has some provisions that I guess I would generously call as unrelated to affordable housing. There's another bill that is even more watered down than that one in terms of promoting housing opportunity and so forth. That's Bill 6107. And the interesting things in that one are that it deletes the phrase in the zoning enabling statute that allows the Planning and Zoning Commission to consider the character of the neighborhood in terms of evaluating applications. And there's a perception among some people that the character of the neighborhood is used as kind of a secret code word for, exclusionary single-family residential zoning. And so they want to take that out of the regulations or out of the statute as far as things that a commission can consider. And that it also, 6107 also requires, towns are already required to adopt affordable housing plans. This makes you update them every 5 years. And the last one that kind of want to mention is the Governor's Bill 3270, which doesn't relate specifically to planning and zoning, but certainly affects you. What it attempts to do is put into statute a lot of the concepts that have been used in the executive orders in terms of remote, virtual, hybrid meetings, and how they work. And opportunities for, members of the public to participate remotely, opportunities for the commission to meet remotely and so forth. And it's a pretty much a 50-page bill. And frankly, a lot of the things in there aren't too controversial. They're basically putting into law the kinds of things that we've all learned to live with over the last year. But there are some things in there that, that may be problematic if enacted as, as written. One is that it essentially mandates that there be a remote option for every meeting. So, even if you all get your shots and town hall opens back up and we start living happily ever after, it would still require you to have, a Zoom link so that people could participate remotely. On the flip side, one of the things that it does is that if you are having a remote meeting, like we are here, it requires that there be a place provided by the town where members of the public can go and watch the meeting. So one of our client town planners was commenting, it's like, yeah, I can just see it now. The entire planning and zoning commission is at home in their slippers drinking pina coladas, and I'm down here at town hall enforcing social distancing among 50 people watching a Zoom meeting. Please don't make me do that. And that's one of the the possibilities under the statute. And
One question about that, Rich.
sure.
If separate from if that passes or not, one of the things I've had to be thinking about from a logistical point of view, that if we were to get, let's say, an application, a special permit application on a big thing that generates a gigantic amount of interest from the town, where normally we would fill up the big room in town hall, and then our fire marshal will be standing in the door, waiting to signal that we've reached capacity and everybody else has to be someplace else and can't come into the room. Logistically, trying to handle that via Zoom can sometimes be a nightmare. Talking several hundred people. If separate from any legislation, can now a municipal agency do it by having people meet socially distanced, saying there's a limit to how many people can be in the room, which there's limits anyway from fire safety, and also having at the same time virtual setup? Is there anything that prevents doing that type of stuff now versus having to wait for any legislation to say it would authorize it or prevent it?
Not really. I mean, right now, meaning today, Executive Order 9H allows that. You can meet in person if you're going to be in person. There has to be the opportunity for some number of members of the public to be there as well. And that was kind of spawned by, and I don't remember which town it was, one town's town council was having all of the members of the town council meet in person, and they were just broadcasting audio out to the world and excluding the public, so that, the public had kind of been clued into the fact that they weren't being able to see what was going on, with all of the members of the town council there in person, interacting with each other. So the current executive order basically says if you're meeting in person, you have to provide the opportunity for some number of people to be there with you, as well as providing a remote opportunity. When the executive orders expire, I think that's probably still permissible. The trick is, at that point, you don't have the safe harbor of the executive orders in terms of how you operate, and you have to go back to kind of the ground rules of FOIA in terms of, public access and so forth. And, whether you can tell people, no, you got to go home and turn on YouTube, as opposed to, we're going to broadcast the sound in this other room over here, or, we'll have the meeting outdoors, or whatever. I think it gets a little more tricky, because, as it stands now, in terms of all those kinds of things, as long as you're reasonably complying with the governor's executive orders, FOIA isn't going to, come down on you, because the executive order essentially says, notwithstanding anything in FOIA, do this. So it's going to be, I don't think it's going to be a huge problem, but there probably will be some, assuming that the executive orders are not continued, or that there are no legislative fixes that kind of cover any gap before new laws take effect. It might require people and commissions to sort of take a step back and reevaluate whether, what you're doing on April 21st complies with the requirements of FOIA, even if you are, essentially, mimicking what you're doing now in terms of providing, Zoom links and so forth. Because a lot of the things in the executive orders were not necessarily consistent with what freedom of information would have wanted or required. They were just basically told, go sit in the corner and we'll take care of this.
Thanks.
Yep. One of the other things in the governor's bill that that personally I think is going to be problematic is, if it passes as written on July 1st, they're mandating the in-person, hybrid, remote meetings, including town meetings. And, when you get into questions like, if it takes effect on July 1st as written, it'll be after the budget is adopted. But, just kind of shudder to think how you're going to have a, 200-person town meeting on Zoom with secret balloting and making sure that, the person's calling in from 401-873-1600, is either an elector or a qualified voter in town. And I know Pomfret had a hybrid town meeting last week, and it worked okay. Thompson had one a couple weeks ago, and I think the saving grace on that one was that the most controversial item was getting adjourned to a referendum. So they didn't need to be as obsessive about authentication and voting and so forth as might otherwise have been required. But some of the towns that have tried doing remote town meetings have spent an hour and a half, 2 hours just letting people into the meeting by show me your license and keep your camera on so that I can be sure that it's still you, and all that sort of thing. And I guess I'll just say that the folks at the governor's office that we've been talking to about this don't appear to have had a significant amount of experience attending town meetings. They mean well, but haven't had a lot of experience with the implementation. One of them was, we were talking about the remote voting, and he's like, well, you can have a verified email address and keep the voting open for a week. And it's like, okay, well, you have the town meeting, someone makes a motion to reduce the library budget by 10,000. We'll keep the voting open for a week and then come back and see how that turned out. And then, somebody will move to reduce the fire budget by 20,000. We'll keep the voting open for a week and come back and see how that turns out. And someone will call the question. We'll come back a week later and see how that turned out. He's like, yeah, I get your point.
Any other questions from commissioners? Unless there was anything else, Rich, you wanted to go over?
No,
We don't have to keep you all night. I know there was a lot of different stuff you went over with us and stuff, but I don't know if anybody else has any other questions.
No, I think
Invariably,
I think I've talked as much as I can. And
well, invariably, we come up with questions during our meetings and ask you anyway.
Okay,
So
yeah, that's fine.
I think we know how to find you and ask you questions, if I remember correctly.
Yep.
Thanks a lot, Rich. It was very helpful.
No, it's my pleasure. I enjoy working with you guys. You're all very, very thoughtful and engaged, and you know that makes everything a lot easier.
That's good. I want to ask Mark, what's his dog's name? He looks very attached to you. Oh, you don't have to
Yeah,
leave.
no, yeah, she shut the camera off even now. Now you got her shy, but that's Ginger, yeah.
Ginger. Oh,
So when we start meeting in person, you're going to bring Ginger to the meetings?
He would love it.
Can be the commission's emotional support dog.
That's right. Could be our mascot, although Gail, you have dogs as well.
Yes, I've got the standard who always sticks his head in at the beginning, and the Jack Russell who spends almost the whole meeting on my lap, but she's small enough you can't see her. But I've got a question for you, Dr. Chairman.
Yeah,
How do we end a meeting when Fred Rich isn't here?
we do have a backup plan, actually. I've thought about that. And I believe I have a really good workable solution that when Commissioner Rich is not here to make a motion, or for some reason is shirking his responsibilities at a meeting and fails in a timely manner to make a motion, I think what we should have as a policy is that Commissioner Young makes the motion.
Move to adjourn.
second.
All right. Just want to make certain before we do that, we didn't cut anybody off in the commission, that any commissioners had any other questions for Rich. Okay. So I know Commissioner Young made it. So hopefully Tim, I don't think anybody's objected to that plan, that you are the backup whenever Fred can't make the motion.
I certainly realize that they are a very large pair of shoes to fill, but I will do my utmost best.
I think I speak for Rich to say that he has the utmost confidence in you. So Fred, for Commissioner Rich, that he has the utmost confidence in you. And who seconded that? Was that?
I did.
Oh, Joe did. Okay. So motion by Tim Young, seconded by Joe Adaletta to adjourn the meeting. I'll go through the quick roll, but I think I know what everybody's vote is. Joe Adaletta,
Aye.
Mark Lackmer,
I
Sid Blodgett. Sid, are you still there? We may have lost Sid. I'll get back to him at the end. Jeff Gordon, aye. Jeff Marcotte,
Aye, and I'd like to say thank you, Attorney Roberts.
Oh, no, my pleasure.
And you did me, Jeff.
I thought I did get you. I didn't, sorry. Gail Dickinson.
Hi.
I've seated Doug Porter. Is Doug still on? I don't think he is. Let me just check. He is not. Okay. We know Fred is not here. Dwight Reinowitz,
Aye.
Timothy Young,
Aye. And again, I'd like to thank Rich Roberts for a very informative night.
Thanks.
and then, well, since Doug is not, well, I'll have to just list that Doug is not present for this one. So I take it that passes. So again, thank you, Rich, for a wonderful job once again, and thank you for the commissioners for hearing what Rich had to say and for the questions.
Yeah.
I don't know how
Thank
many
you,
of you
Rich.
are signed up for Saturday's virtual meeting. I am.
I am.
650.
Ah. Well, I'm sure there's going to be, what, an announcement, Rich, at the start of the meeting acknowledging that Woodstock Planning and Zoning is #1 in the state. I'm assuming we're going to hear that.
I'll put in a good word for you.
Thanks. Thanks.
I have a question.
Well, we've already adjourned.
Well, it's not a meeting question. It's just a question for Rich Roberts. I registered for Saturday's event, but I don't have a link to get to it.
It was a email from a Shirley
Shirley
Yeah.
Parent.
Shirley Perrin.
Do you know what date it was sent?
That was sent today.
Today,
Oh, okay.
150,
I
141.
got one that came to me in January when I registered.
that was just the.
Oh, yes, but it has a Zoom link on it.
Acknowledge that you registered, but the link came today.
Okay. I had a lot of
okay.
internet problems today. That's probably why I didn't get it. Thank
'Cause
you.
I got one that said this is from January, it says, click the link below to join the webinar. It
Hmm.
must- So who did it come from? I
It
didn't-
was updated today. The start time is 9 a.m. It
Oh.
said today. So I think originally it either said 8 or 8:30, but it said 9 a.m., 9 to 4:30 today.
Oh, I didn't get that email, I think. Who did it come out from?
Probably Shirley Perrin.
Yes. And I'm forwarding it to you, Delia. I'll forward what I just got from Shirley Perrin.
Can you forward that
Thank
to me
you.
as well, Joe? Because I didn't seem to get that email.
Will do.
Thanks. It may be sitting in my spam, I'm wondering. Shirley Perrin. No, thanks for letting me know because I wasn't,
Yeah, about half the presenters had the link end up in their spam too. So I think it's worth looking there.
yeah, I'll take a look and see. I bet you it's probably ended up in my spam because I probably don't get much email from from Shirley Perrin. So, but I'll find it. But if I don't, if you don't mind, Joe, just sending it because I'm looking forward to the conference.
I
So,
just found the email, so I
right.
got it.
Oh, you have it? Okay.
Yes.
All right. Well, we'll be on for then for Saturday. And correct me if I'm wrong, Rich, but any commissioner who isn't able to attend, is there still the option to buy or get that big book that we got mailed to us when we registered?
Yes, and I think they're trying to figure out some way also to basically be able to sell you a recording of the program. It'll probably be like one of those Grateful Dead box sets of, 15 CDs of PowerPoint presentations. So,
Well, I have mine, and actually, I get one of these every time, and I actually do bring them to meetings because it is actually really helpful stuff that's in there. So cool. All right. Well, thank you, everybody. Stay safe, and then we'll catch you in 2 weeks. We'll meet again.
all right.
Have a good evening. Thank
Take care.
you.
Bye.
Thank
Bye.
you. Good night.